Hi everybody. I think we can begin now. Thank you all for taking the time out and joining us today as we help you navigate what a flipped structure is and what are the basics around it, what are the rules, regulations that apply when you want to set up a flipped structure, and what as founders you need to know when you are thinking to move your headquarters outside, right? We'll also quickly touch upon what is a reverse flip. So I'm sure you must have been following the news, and reverse flip has been a trend for the last couple of years. So we'll also spend some time to just give you a quick overview on what a reverse flip is, and what are the ways in which you can do a reverse flip, right? So quickly diving in, right? This is the agenda for today. We'll spend some time to understand what is a flip structure. We'll also go through some case studies. We'll give you a quick overview on what's a reverse flip. My colleague Daria will be joining us today. And then we'll open the floor for questions, right? Feel free to drop in your questions in the chat box or in the Q&A section, wherever you have any questions, and we'll try and answer it while we are doing this. If at all anything remains unanswered, we'll try and pick it up afterwards. Right, so let's get going, right? Quickly. What is a flipped structure, right? A flipped structure or an externalized structure is also what it's called, is when Indian founders have a startup and they feel like they want to move their headquarters outside India, right? Now, if you do a startup in India, typically what happens is you will set up an entity in India, right? And that entity becomes your holding company or your value generation entity, right? Where all the value of the startup will generate and eventual exit will happen at that entity, right? Sometimes what happens is founders feel for multiple reasons that their product will work better in a non-Indian setup, right? Or they feel that their customers will more be from outside India, or they may also feel that they may get a better investor base outside India, right? That's when they look at flipping or externalizing their structure, right? Now, what I mean when I say flipping or externalizing, I mean that they will move their headquarters outside India, which means that the holding company or the value generating entity will be outside India and not in India. Okay, what remains in India will be a back office or something of that sort. But broadly, what it means is that your value generation will start happening outside of India, right? Now, founders in this scenario may continue to stay in India, or they may also eventually move outside India if they feel the need. Right now, if you see the diagram over here, if you see there is an Indian company which is ICO, and what we are trying to show is that how the when a flip happens, what happens is that the Indian company, which was the original startup entity, becomes a subsidiary of the foreign holding company, and then the foreign holding company becomes the main entity, right? Quickly taking you through what are the benefits of flipping, right? One, as I mentioned, is that when you move your headquarters outside India, or when you move your holdco outside India, what happens is funding or receiving funding becomes a bit more easier because you get a wider investor base. Sometimes foreign investors are not very comfortable in investing into India because, as the saying goes, it is kind of difficult to remove money from India eventually when the exit happens, right? So some foreign investors or some foreign funds also, for that matter, are more comfortable with investing in a foreign holding company, right? Rather than putting money in an Indian company, right? So that's one benefit. Second benefit is that better IP protection, right? So Indian IP laws are not considered to be the best in the world, right? There are jurisdictions like Switzerland and other US for that matter, where legal protection of IP is much more regularized and much more robust in that manner, right? So when it's like a SaaS company or a tech company, their IP is their main asset, right? So many times what happens is moving headquarters abroad means also moving your IP abroad, where it can get a better legal protection. The third is that some foreign jurisdictions like Delaware in the US or UAE for that matter, they have much reduced compliances and they have very flexible foreign exchange laws, right? As compared to India, where your regulatory compliances and exchange laws are pretty stringent. So that is also becoming one of the reasons why people want to move their headquarters outside India. One more benefit is that, of course, exit opportunities become much more wider when you are headquartered outside India, right? You can list on international stock exchanges. You can also look at strategic buyouts with international players, and all of that becomes much more attractive when you are domiciled outside India. And of course, efficient corporate tax laws, right? So India has a corporate tax law of around 25%, but there are jurisdictions where the tax rate becomes much lower when you are housed outside India. Other softer points is that, of course, some startups, some customers of startups prefer remitting money in dollars, right? When they have to remit, say for example, a startup has international customers, then these international customers are not very comfortable paying these startups in Indian rupees, which they will have to, if at all this startup is housed in India. But when the startup has a foreign entity, they can easily take money in foreign currency, right? Which becomes a great USP or a great selling point for them to attract more customers. So these are softer points, but broadly, these are the benefits of flipping to a jurisdiction which is outside of India, right? Now, while we've all looked at the benefits, I think it's very important to also know that there are multiple factors that you need to consider while taking this big step, right? And again, I want to speaking to all the founders that while setting up a foreign holding company, it looks very interesting on paper. But if at all you do set it up without any real benefit or whether without any real tangible value that's happening, to unwind that structure is a real big issue, right? So, I mean, I would urge everybody to please consider all the factors, look at all the implications, and then only decide to go and do this, right? Because unwinding these kind of structures is pretty complicated, right? Quickly taking you through the key considerations, right? Like what all you need to look at before taking this decision or not. The first is basically your choice of overseas jurisdiction, right? So popular jurisdictions are US, UAE, Singapore, right? Even UK for that matter, and even the Netherlands is what we are seeing. But all of this, the choice of where you want to move your headquarters becomes very crucial, because then that will always remain the headquarter of the company. So your customers, your investors, everybody has to then talk to that entity in that jurisdiction, right? So that becomes an important factor. And of course, keeping in mind tax and regulatory, but you also need to look at commercially, right? Whether it makes sense, will you be able to visit that location, all of that when the time comes. So that's one thing. Tax and regulatory, right? While Area will take you through these considerations in the case studies, but just quickly telling you all, two main regulatory considerations. One is ODI, which is overseas direct investment, and one is FDI, which is foreign direct investment. ODI is when Indian residents invest money outside India, and FDI is where foreign investors or foreign residents invest money in India. Okay. Now, in a flipped structure, also called as an ODI FDI structure, is where there is an ODI leg of the Indian founders investing in a foreign jurisdiction, and there is also an FDI leg because that foreign entity will have an Indian subsidiary, which typically works as a back office in India, right? So that's why it's called an ODI FDI structure. Um, Valuation, pricing, compliances, all of that apply on both legs, which need to be taken care of. The third is sectoral approvals. So if your startup is operating in a sector in say, for example, in which say FDI is under any sectoral caps or condition, then that needs to be seen. Also, from an ODI perspective, um, if the FEMA rules say that any overseas investment in some sectors is not permitted, for example, any ODI and financial services sector has some additional conditions that need to be looked at, then basically then all these also need to be factored in. The fourth is ESOPs, right? Now, say for example, you have a startup in India and you have issued ESOPs to your employees, right? Now, what happens is that when you move your headquarter outside India, your employees will continue holding ESOPs of the Indian entity, right? Now, in a flipped structure, the Indian entity has no real value. The value generation starts happening outside India, right? So these ESOPs technically need to be moved to the foreign entity, right? So I'm saying the how to move those ESOPs to the foreign holding company, that also needs to be factored. Uh, the fifth is POEM, right? Now, quickly spending 2 minutes on what is POEM, right? So POEM is basically place of effective management. It's an Indian income tax concept. And what it says is that if there is a foreign entity, the head and brain of which is sitting in India, then that foreign entity is considered as a tax resident of India for income tax purposes, right? Now it means that what the Indian tax authorities are saying is that if Indian founders are running a foreign company sitting in India and taking all the decisions from India, then that entity where all the value generation is happening also needs to pay tax in India, right? Now there are ways and means to kind of mitigate this exposure, but I mean that's also something that needs to be absolutely considered while we are structuring a flip structure, right? And the last is round tripping, of course, right? So pre 2022, round tripping was not really spoken of in any of the FEMA regulations, but now post 2022, RBI has gone ahead and kind of allowed a one level round tripping, which is typically how a flipped structure is done. So these are a few factors. I'm sure when we look at each case, there will be more and more factors which you'll have to look at and kind of weigh all these factors before even deciding to flip your structure. Moving on to case studies, I'll let Daria take this up.
Thanks, Priya, for giving us a brief introduction of flip structures and the growing intent of the founders based out in India to explore flip structures with their overseas holdcos. Now, let us deep dive into some case studies as to setting up of a flip structure. The first case study that we are discussing here is for setting up a altogether new structure for the founders, wherein they intend to have a overseas holdco. And in this case study, what we are discussing for is to set up a overseas holdco for founders who are Indian residents and are based out of India. So as you can see in the structural diagram here, we have Indian founders who want to set up a overseas holdco with an Indian entity which will in turn carry out the operations. So, under the Overseas Direct Investment Regime of RBI, that is FEMA norms on ODI, currently Indian individual residents are allowed to do an overseas direct investment in an offshore entity under LRS limits of USD 250K. However, there is one condition that And when an ODI is made under LRS route, then the offshore entity cannot have a further step down subsidiary. So to have a flip structure wherein there is an Indian subsidiary, founders cannot do a direct LRS ODI transaction, and for that reason, it is pertinent to ensure that the founders first create an LLP in India with the predetermined inter se profit sharing ratio among founders as may be agreed inter se among them, and they fund the Indian LLP with the bare minimum capital contribution on the as desired amount which is required to be funded to the offshore vehicle. Thereafter, the Indian LLP will do a ODI transaction by way of remitting money under the ODI route up to 400% of its net worth by subscribing to the capital of US entity or an offshore overseas holdco. Once this overseas entity is set up, then that entity would do a foreign direct investment in India by way of setting up a Indian subsidiary which is wholly owned by such overseas vehicle, and that entity would have to be subject to FEMA norms on FDI, wherein it would have to comply with applicable sectoral requirements, applicable percentage shareholding norms. Say, for instance, if the investment is in insurance sector, then the limits are 74% of FDI, which is now proposed to be liberalized to 100% under automatic route. So all those FDI related norms would have to be complied with by the overseas holdco while incorporating the wholly owned subsidiary in India. In addition to this, the Indian founders would have to ensure that the offshore company's POEM status does not trigger in India. To explain this further, as Priya mentioned, that the concept of POEM is like a place of effective management wherein the tax department in India understand that although there is an entity overseas where the head and brain of that entity sits out of India, that is the founders who are resident of India, then for tax purposes, the tax department might still consider that entity as an Indian resident entity and tax the entity accordingly. So it is also important for founders to take care of the aspects pertaining to POEM as well. And in the context of IT sector, founders generally tend to have this overseas setups or overseas holdco structures wherein they raise funds from overseas or global investors at offshore holdco level, generally in US, by issuance of safe notes and other such uh, instruments like Y Combinator and etc. And then in turn, the offshore entity funds the Indian entity. And the Indian entity kind of acts as the back office entity for such IT sector founders. And in this context, the Indian entity and the US entity are also required to have an appropriate intercompany service agreement so as to comply with the transfer pricing norms, the benchmarking norms, wherein the Indian entity would have to ensure that it is charging a bare minimum markup on the cost plus services that it intends to provide to its holdco in any overseas jurisdiction. So this is kind of a broad structure mechanics for an Indian founder intending to set up an overseas holdco, wherein still the operations or back office operations in such overall structure are desired to be carried out from India. Mm. Now we move on to the next case study on setting up achieving externalization stroke flip of the structure in case of an existing India overseas structure through share swap. Just so here, what is happening is there is an Indian company already in existence which is having a subsidiary. Now that Indian company currently is owned by the founders, but the founders now intend to do a externalization or flip by setting up a overseas holdco for further fundraising or for any other commercial reason that they feel that having a overseas holdco would create more value for the investor pool and enable easier capital access for them. So in order to achieve this desired structure, that is founders owning foreign company then in turn owning the Indian entity 100% and Indian entity owning the subsidiary company 100%. So one brief mechanics to achieve this proposed structure is through share swap, wherein the founders and the other investors who are holding shares of A Limited would exchange their shares in A Limited with the shareholders of FCO, that is themselves, and in lieu, A Limited will issue them its own shares. That is, E Limited will issue its own shares to FCO, whereby the resultant structure becomes like this, that the founders and the investors own FCO, FCO 100% owns A Limited, and A Limited continues to own its subsidiary, that is 100% subsidiary in India. Here, it is pertinent to note that such share swap, although permissible under the ODI/FDI norms in India, relevant reporting norms would have to be complied with, wherein the Indian founders would have to ensure relevant filings under ODI norms, while EA Limited would have to ensure relevant filing under FDI norms. The transaction of share swap would have to comply with valuation norms as well under FEMA, Income Tax, and Companies Act as may be applicable. Further, it needs to be also noted that EA Limited is now receiving FDI from FCO and hence it needs to comply with the sectoral caps and the attendant conditions to FDI as may be applicable. So this is broadly as to the implications for share swap. One other important aspect to take care here is that while thinking of a reverse flip to share swap, it is important to note that there would be capital gains tax implications on founders and investors holding shares in A Limited. So that would also have to be factored and weighed in before going ahead with the implementation for achieving flip structure by way of a share swap. And where the shareholders of A Limited are other non-resident, then applicable treaty benefits would also be available to them on transfer of shares of A Limited in share swap model with the shares of FO. Having said this, what are the other ways and mechanics to achieve flip or externalized structure wherein the founders are already having an Indian entity which is kind of acting as a headquarter currently? Then apart from share swap, the other models to achieve those structures are mergers, buybacks, and setting up a altogether new entity followed by a share swap as we discuss currently. So these were the broad structural options available for achieving flip stroke externalized structure, wherein before deciding on any of the alternative or any of the mechanics, the founders would have to weigh in on the tax and regulatory aspects of each of the explored alternative, including for the points that Priya mentioned at the inception, that would help them decide as to the structure in a timeline wise manner as well as ensuring that it entails least possible tax outflow and the overall structure remains regulatory compliant from a FEMA exchange control perspective as per the laws of respective overseas host country jurisdiction. Now let's discuss a bit about reverse flip. So what is reverse flip? Then reverse flip is exactly opposite of flip, wherein the entity is having a overseas global holdco already and an Indian subsidiary, wherein the promoters or the founders believe that it is essential for the entity to shift its headquarters from the overseas jurisdictions to Indian jurisdiction in order for the company to maximize value for its investors. And this is a term which is widely used in the capital markets these days because few of the large Indian IT sector and other startup giants have been increasingly adopting for reverse flips. Few of them include Grow, Zapto, then Pine Labs, and there are few others in pipeline like Flipkart, etc., who have shifted their overseas holdco jurisdiction from Singapore to India by way of an appropriate mechanics from structure to make the Indian entity as the global holdco or like a holding vehicle itself. The reasons for this reverse split are as discussed herein, that is currently the Indian funding ecosystem is thriving, wherein the valuation for the Indian market players are way high as compared to the valuation that would have been available for similar such players in any other jurisdiction like US, Singapore, UAE, etc. To give you an example of same, if if we have seen the listing of LG and Hyundai in recent days on the stock markets in India, the PE multiple at which those firms are trading in Indian stock exchanges is way high than the PE multiple of those same entities holdco in South Korea. So these high valuations kind of act as a lucrative reason for the founders to shift their bases back to India, also providing for the investors an option to exit the company by way of an IPO or a PEVC deal at an appropriate valuation, which is higher as compared to other global jurisdictions. The other reason for a reverse flip is to provide for an option to exit for select investors as against in case of a global holdco model wherein it is not possible for the Indian entity to pick and choose the investors or to give selective exit to a few select investors, while reverse flip enables that flexibility because as against overseas holdco holding shares in Indian company, the investors directly stand on the cap table of Indian entity and hence it is possible for the investors to exit as and when they desire for. In addition to this, the reasons why there is a more and more trend toward reverse flip is enhanced ease of doing business in India. And apart from that, there is also a talking point as to Gift City acting as a destination for reverse flipping, which can be seen from the consultation papers published by IFSCA in order to promote it as a jurisdiction for reverse flip for the overseas located global companies, wherein the regulator intends to have IFSC as a platform come jurisdiction as a preferred route to onshore or reverse flip their overseas structure by interposing gift IFSC. But this currently is under consultation stroke reports phase, wherein relevant regulatory enablement or regulatory amendments are yet to be made, but this is kind of being discussed of currently at regulatory levels. So these were the brief reasons for the rising trend of reverse flip in India. Now let us just briefly touch upon one case study in a, on how to achieve a reverse flip in case of an existing overseas holdco structure. So let's move on to next slide. So this slide talks about a case study on reverse flip through swap of shares, wherein there is an overseas holdco by the name E Limited, whose shareholders are founders and global investors, and that E Limited is holding 100% shares of B Limited. Currently, the founders contemplate to reverse flip the structure to India, whereby their Indian entity becomes the holding company come operating company. So in order to achieve this structure, again the founders contemplate to do it by way of share swap, wherein the founders would incorporate new company and that new company is owned by the founders and global investors in same and like manner as the A Limited shareholding stands today. Thereafter, the new company shareholder would swap their shares in lieu of shares of A Limited, whereby new company is owned by the founders and investors directly, and A Limited becomes the subsidiary. There is the mechanics being followed in this structure would lead to a structure wherein the new company is the ultimate owner of the business in India, and the founders and the investors who are global investors stand on the cap table of the new company in India. Again, under this structure as well, relevant ODI FDI norms would have to be complied with. In addition to that, the Indian entity would have to comply with relevant FEMA filings, and same is the case with the founders for FEMA filings, valuation norms compliance, income tax on swap of shares, subject to treaty benefits if any. So this was broadly as to the case study on reverse flip through share swap model. Apart from this, there are a few other models as well for reverse flip, like by way of a merger, which people prefer these days in case of Singapore holdcos, like in the case of Zepto, Pine Labs, Grow, etc., wherein they have merged the overseas holdco that is in Singapore with the Indian subsidiary, and the Indian subsidiary then in lieu of merger issues the share to the shareholders of that Singapore entity and achieves the resultant structure in a manner whereby the Indian entity becomes the single standalone entity, and on which the shareholders are Indian shareholders who are investors as well as the global investors as well, and thereafter it can plan for an IPO or an eventual exit by way of a PEVC investment. So these are broad options again for achieving reverse flip, which are similar to flip, that is share swap, mergers, and buybacks, and etc. Any questions that the audience has? Happy to answer.
If anybody has any questions, feel free to ask, else you can write to us at support at Treelife, and we'll be happy to answer or even get on an exploratory call with you guys in case you want to explore. All right. I guess there are no questions as of now. Thank you, everybody. This was quite quick. Thank you for joining in. We will be in touch. Please reach out to us if you need any help. Thank you very much.